Welcome to Ethics, Analytics, and the Duty of Care. We're in Module 8. That's the last module, talking about ethical practices in learning analytics. And we're just starting off this module. I'm going to do a reasonably short look at efforts to regulate artificial intelligence and analytics. So, to begin with, let's consider what the scope of regulation is. Basically, the idea here is to try to put some parameters or boundaries around what we're talking about. I said at the very beginning of this course that I would interpret the concept of analytics and AI very broadly, and I have. And I would consider the context of ethics very broadly, and I have. And take into account the wide range of applications and the wide range of issues that arise. And these principles continue to apply as we talk about the scope of regulation. But let me draw from Corinne Kath, and we'll identify a few of the major areas covered under what regulatory agencies are trying to do. First of all, what might be called ethical governance. And this is an attempt really to zero in on what Kath calls are the most pertinent ethical issues. For example, fairness, transparency, privacy. Now, my argument to some degree on this is that over time we will probably find that our tastes and our interest in the issues raised by AI will vary. And right now we're focused on fairness, transparency, and privacy. And 10 years from now we might be focused on three very different things. Similarly, from society to society, different issues have different levels of importance. For example, privacy in a large city is one thing. Privacy in a small town like the one where I grew up is very different. But nonetheless, the idea here is that there will be a continuing interest in the particular ethical issues that are raised by AI. Secondly, the scope can be thought of as covering, well, what Kath calls explainability and interpretability. For example, the right to an explanation of algorithmic decisions. We've already covered the idea of explainability in AI, and we're going to revisit that in this presentation again as well. But there is this sense that people should know about what's happening in an artificial intelligence or analytics application so that they have some understanding of what they need to fear and what they don't. Or even whether they need to fear anything or whether they can just go on with their lives. This is a bit different from the idea of issues. This is more looking at the idea of AI and analytics from the perspective of risk, but informed risk, and that's the intent here. The third area of regulation could be covered under the heading of auditing. These are, as Kath says, mechanisms that examine the inputs and outputs of algorithms for bias and harms. I think it goes beyond that, and we'll see some cases where it goes beyond that. But the idea here is that even if we can't explain everything, and even if we can't come to decisions about the ethical issues on a broad scope basis, and of course I've argued that we can't, there is still grounds for regulation just based on the principles of good management, good software practices, and good corporate practices. And so auditing and accountability would certainly be within the scope of regulation. So, as you can see, I mean, these scopes don't really narrow the field at all. At least I don't think they do. But they give us a sense of the different sort of approaches that are taken by different efforts at regulating artificial intelligence and analytics, and arguably any attempt to regulate without addressing all three of these would be incomplete. I said we'd revisit explainability. Let's do that now. Now, when we talked about explainability, for the most part, we talked about explainability in the sense of the first of these types, which is titled rationale, or reasons behind a decision. And to a large degree, I argued that we're not really going to get explainability in the sense that we know an AI system is going to follow a nice, neat if-then type rule or regulation. We won't be able to appeal to it. And even when we try to approach the issue of explainability counterfactually through, for example, the semantics of possible worlds, there are going to be different perspectives, different points of view that will realize the explanation differently. An explanation very much has to do with point of view, the range of options you are expecting, and the alternative thing that you thought might have happened. But that's just the rationale, and as the slide here says, the ICO and the Alan Turing Institute actually identify 6 main varieties of explainability. Now, I argue on a technical ground that the other 5 aren't really explainability, but they are things that need to be considered whether or not we call them explainability. So these are the sorts of things that someone regulating AI would want to know more about with respect to an AI or analytics engine. For example, responsibility. Questions come up like, who made the system? Who designed it? Who created the model? Who implemented it? Who owns it now? And if it does something or makes a decision, who do you talk to get some sort of review? And the presumption is, and I think it's a fair presumption, that what the AI says or does shouldn't necessarily be the final word. Another area of explainability, and we've covered this in a set of 4 videos, data. What data went into the model and how the data was used. And we know already from looking at it previously all the different questions that entails. And we haven't even yet finished talking about data in the context of this course. You know, I mean, there's artificial intelligence and analytics, and then there's this thread about data that runs through it. And I suppose that's always been the case with computer science, and it's certainly the case with modern neural network AI, which depend on data. Another type of explainability is fairness. That one's harder to get at because it's hard to know what counts as fair. When we looked at social contract theory, we looked at John Rawls and the idea of justice as fairness. But what counts as fair might be perceived very differently from one person to the next, and might be applied very differently from one context to the next. And fairness does not simply mean that the AI is unbiased and individuals are treated equitably. And when we talked about the duty of care, for example, we talked about the importance of getting the perspectives and indeed even getting the involvement of those who are impacted by the AI in the design of the AI. And that's not a thing you can just measure as a fairness measure. But it certainly does seem to play a significant role in our idea of whether AI is fair or not fair. Another dimension of explainability could be safety and performance. And these would align with typical and I think reasonably well understood computer science auditing procedures. And these address issues of accuracy, reliability, security, robustness. All of these are already governed under standards set by IEEE or the ISO, and all of these are indicated through various common practices or methodologies. And then finally, and we talked about this in the previous module, impact, understanding what the impacts are of the use of analytics or AI and how the effects are monitored and how decisions are monitored. But again, impact isn't a simple phenomenon, and it's not easy to trace a specific impact back to a specific thing that you did in setting up the AI setting up the AI model or providing it data to learn from. Still, this again gives us a framework for thinking about explainability, or thinking perhaps more accurately about the way we would like people who create AI systems to be accountable for what they've created. So this is perhaps a good way of describing the information that regulators are going to need from the providers of AI and analytics systems. And if you're in the process of building or implementing a system and can't provide answers to all of these questions, then I think that regulators will be in a good position to question exactly what it is that you're doing, and ask for some sort of guarantees or safeguards, because what you're doing might be, in significant respects, dangerous. This, to a large degree, is the approach taken in Europe. Earlier this year, that would be 2021, a draft proposal called the AI Act was presented. Basically, a regulation laying down harmonized rules on artificial intelligence. I've got the link to it here on the slide, plus links to a couple of summaries. The web is littered with summaries, so you don't need to depend on me for this information. But there's a few things that are worth noting. The AI Act takes what may be called as a risk-based approach, and in fact I read in several documents that there is a general consensus that AI that pose different levels of risk should be treated differently, and obviously AIs that pose the greatest risk should be regulated most stringently. AI that poses the least risk, you're almost like anything goes. So at the high end of that risk scale are uses of AI which the proposed AI Act says should simply be banned, and these are all listed under Title II of the proposal. And this is a quick summary. Obviously read it for more details, but it bans AI tech that is subliminal or is based on subliminal methodologies, so that the individual isn't aware that they're being manipulated in some way. Whether that would cover things like dark patterns, I don't know, but if it does, I'm not going to complain. Also, AI and analytics that exploit vulnerabilities. And here, we could ask whether that includes things like the dopamine hit that you get from receiving a like on a Facebook account, um, or whether you're engaging in addictive behaviors, like doom scrolling, just endlessly scrolling because, it just never stops. Um, Also, banned are applications that create some sort of social score or ranking based on your social media activities, which is interesting because it's a contrast with China, which has taken the opposite approach. And then, subject to a number of conditions, uh, in fact, the number of conditions, the description of the conditions is the longest part of Title II, banning real time biometrics for identification in public places. So, those are the things that the European Commission feels are the most risky applications of AI. Um, Interestingly, as I look at that and think about that, it doesn't include things like what we've been calling in the chat or in the discussions AUX, or um, autonomous armed autonomous quadrupeds. Um, and it's interesting that there isn't a specific ban on joining AI with weapons, although you could interpret that as exploiting vulnerabilities. There's also a fairly significant set of regulations regarding compliance with existing rights and freedoms in areas that are considered high risk AI. And then, just generically, where there is a potential risk, AI needs to bear a CE mark of product compliance, showing that it's been developed under processes and procedures that provide a reasonable degree of assurance about their safety and about their security. All in all, I think it's a pretty reasonable approach, although I would want to say explicitly that we don't want weapons on our AI. The other thing is, and I think this is very much worthy of note, the things that we think are risky now might not be the things that are actually really risky. And the things that we don't think are really risky now might be the things that turn out to be really risky. For example, using engagement as the primary consideration when designing recommendation algorithms. We've talked about this already. People seem to like to engage in fake news and controversy. It turns out that that's really risky for a society, and that there may be bad effects, and that it exposes a society by making it vulnerable to being, if you will, hacked by fake news and fake information, which arguably is what has been happening to the United States and the Western world in general recently. So these risks are going to move around, and there, in a framework, there needs to be sufficient flexibility to move specific practices in and out of different risk categorizations to allow for a reasonably flexible response to them. This is the sort of thing that comes up. People, especially in the United States, have decided in many places that facial recognition algorithms are too risky to use at all. And so there have been bans in places like Massachusetts, Maine, and Minneapolis. And companies like Amazon, IBM, and Microsoft are reported as saying they will stop selling facial recognition technology. And all of this is documented. But as TechCrunch points out, they run a service called Crunchbase, which tracks investments in technology companies, including AI companies, and according to them, the investment cash is just rolling in, suggesting that there's a bit of ambiguity society-wide as to whether facial recognition is a really risky technology that should be banned or a really good business opportunity that should be funded. And the cynical among you, and I include myself in that, will say, well, it's both, right? And so that's going to create some pressures. And that's one of the risks of regulation or taking the regulatory approach is often the people who write the regulations are the same people who benefit financially from certain regulatory regimes. You know, it's a lot like letting cable companies write your country's communications policy, or pharmaceutical companies writing your country's drug patent law. And here there are cases where AI and analytics companies will have a hand in writing the regulations that govern AI and analytics. And they make money from what we may consider risky behaviors. Now, in Europe, the government is taking the approach that their money doesn't buy freedom from regulation, but that's not something that applies across the board. In the United States is in a bit of a flux, obviously, because of the fairly dramatic changes of government they've had recently. The NIST plan, describing an American AI initiative, was developed under the Trump administration and is dated 2019. Reading it, though, there are elements of Trumpiness in it, to be sure, like the America First approach. But to a large degree, it reads like a reasonably well thought out set of principles. And the overall 5 principles that we could say guide the initiative are the sorts of principles we would expect from the United States, generally. And I can't see Joe Biden changing these dramatically. They want to drive technological breakthroughs. There's certainly the sense that getting better at AI is an imperative. They also want to drive the development of appropriate technical standards. And again, that's an approach that does characterize what the United States has done in other areas. A lot of the impetus for things like the International Standards Organization or the IEEE comes from the United States. And they do have standards in a lot of product areas and services. They're also focused on training workers with the skills to develop and apply AI technologies. That presumably is a good thing. But now here are the I was going to say here are the Trump things, but I don't think these are Trump things specifically. Protecting American values, including civil liberties, privacy, and fostering public trust and confidence in AI technologies. And this reflects the tension that always exists in the United States. It's very much a nation that believes in civil liberties and privacy, and these will be of primary importance. At the same time, the United States is a nation that believes in and trusts its industries, including its technology industries. And industry has always had a large say in American policy and development. So there needs to be a mechanism to enable people to be confident that their rights and freedoms are being respected, and also confident in the companies that are developing and deploying this technology. And then finally, um, they're looking for an approach that protects the American technological advantage in AI, while still promoting an international environment that supports innovation. And here, longer term, we can expect to see things like copyright, patents, and other IP regulations come to the fore. In Canada, Canada has adopted basically, well, at least according to the report by the Privacy Commissioner, a rights-based framework that would explicitly allow personal information to be used for new purposes, but within a rights-based framework, would create provisions specific to automated decision making, and as I suggested in one of the earlier slides, include an accountability requirement that could, for example, take into account the different types of explainability that I listed previously, although subject to the difficulty of providing explainability of artificial intelligence and analytics applications. As well, there's quite a bit of movement, and I'm not really sure where it will go, with respect to copyright and intellectual property generally. Also, I'm not really sure where Canada will go with respect to ownership of data and data privacy. There is a strong streak of wanting to protect the privacy of Canadians. At the same time, there's an openness to allowing companies to develop and implement technology with the broadest freedom possible. So, a lot of open questions, I think, still with respect to Canada. Follow Michael Geist on that. He's probably the national expert on the subject. China, there are various discussions of China. Now, obviously, I don't read Chinese, so haven't been reading these in the original. I did look at them, but they were all in Chinese. But this is something that we've seen develop overall over the years. Right now, most recently, they have released a set of draft guidelines on recommender systems, and what I noticed was the provision in there that allows individuals to turn them off, which I think would be very disruptive to, say, Facebook's or even LinkedIn's business model. And although China hasn't emphasized privacy in the past, there is more of an emphasis now on requiring user consent for the use of personal data. What's really been interesting in China recently, however, has been the limitations that it's been imposing on tech companies generally. There have been a number of high-profile announcements in that regard, including prohibitions on tutoring and education services companies selling services to people under the age of 18. These limits would also prevent platforms from violating user privacy and engaging in practices that are harmful, like encouraging users to spend money or promoting addictive behaviors. Haven't seen that sort of emphasis in the Western world, but I wouldn't really be opposed to them if I saw them implemented. There's a big gap between subliminal practices and exploiting the vulnerable and encouraging people to spend money and encouraging addictive behaviors. You might think of it as two of the same sorts of things, but I think there's a bit of a level setting issue here. The companies in the West, I think, will have greater freedom to engage in practices that are kind of like this in the interest of providing them with good business models. Similarly, in China, especially recently, there have been strong antitrust and anti-monopoly laws, and with specific liability for abusing a dominant market position by discriminatory pricing. And then, as well, I've noted some expression of concern about working conditions in China, especially with respect to things like AI surveillance. So, I found this article as well, a statement on accountability from the Global Privacy Agency, and I really think that that's where a lot of the emphasis in regulation is going to be, especially over the next few years. And there are 6 provisions here that I've listed, and there are more provisions as well in this document. But accountability includes things like assessing the potential impact to human rights, testing the robustness, reliability, etc. of the system, keeping records, which I'm sure Facebook wishes they didn't have to, disclosing data protection, privacy, and rights impact assessments, again, so that they don't need to be disclosed by whistleblowers or court orders, disclosing the use, data, and logic involved in the AI, and ensuring that accountable human actors are identified. And again, you see a consistency here with these principles of accountability with the definitions of explainability that we saw earlier. And so overall, the regulatory framework is going to require some kind of mechanism for accountability. But the danger here is that it'll be very prescriptive. Well, we'll talk about that. So, but first, let's consider some other regulatory areas that are outside of AI and analytics generally. The one that springs to mind right away is data regulation. We have the European General Data Protection Regulation, and there are more in Canada, the United States, elsewhere. There are regulations on data. I've considered them kind of marginal to this, that they have an impact on the ethics of AI, but they also have a wide applicability outside that specific scope. Another area, and I mentioned this previously, intellectual property. There are various issues that arise. The big one recently is defining the authorship of AI-generated content. And the question is, who owns the content, if anyone? If a if a monkey can take a selfie, so can an AI, and if that happens, who owns the result? It's an interesting question. But there is also intellectual property issues about data models, data in general, specific data, the processes involved in cleaning data, etc., etc., etc. Right now, artificial intelligence is pretty free and easy. Most of the initiatives are open source. Even those that are proprietary are sharing quite well. As the dollar values rise, and as the importance of AI to the economy and to culture generally rises, I would expect more and more debates about ownership and IP. And then finally, just the general area of civil wrongs, or torts as they're called, covering things like manufacturing and design defects just generally in AI, particularly if they can be identified to cause harm. That's going to be a hard one because, again, there isn't going to be a simple causal chain from the design of an AI to somebody got injured. Where you can do that, sure, and we might see that in the case of obvious things like automated cars or self-driving vehicles generally. But for things like, say, an education recommender, you could wreck a person's life by badly mismanaging their education, but how could you ever prove the consequences in a court of law? I just don't see it happening. You similarly, not just design defects, there's also the failure to warn people of risks. This will be especially the case in the data management area, where people might not be aware of the risks that they incur, not just to themselves, but to other people when they share data. Um, Even simple things like I've had arguments with survey companies. They call me, they want to do a survey. Fine, I'll do the survey. And then they ask me personal information about my wife. Well, it's not my information to share. And if I'm careless about sharing that information, she might be harmed. And if I'm not thinking about that ahead of time, that's the sort of thing that could be a problem. Companies, I think, have an obligation to warn if the information that you're sharing is a risk not only to yourself but to others. The thing with regulating, well, anything, but especially regulating artificial intelligence, where it's really not clear that you can identify the benefits, is that it becomes subject to something called Goodhearts Law. And the idea is that, and I quote here, any metric ceases to be a valid metric the moment it becomes a target for optimization and hence gets metric hacked. And we've seen it in research, the phenomenon of p-hacking to increase the significance of experimental results. The example that is given in various places is probably apocryphal. It's certainly colonialist, but the idea is that the British administrator in India wanted to eliminate cobras in the city. And so what they did is they put a bounty on cobras, which sounds like a good idea. And it did work at first, but as it transpired that because there was a bounty on cobras, people started raising cobras and then killing them and handing them in to collect the bounty. And raising cobras became very profitable. And inevitably some escaped, and inevitably once the administration realized that the system wasn't working, they rescinded the bounty, at which point all of the cobras that had been raised were released, and the city had many more cobras after the bounty than it ever did before. That's an example of Goodhart's Law, and you can see that people zero in on the bounty and forget about the point of the law, which was to limit the number of cobras. Now, if it had been possible to reward the city overall for limiting the number of cobras, that might have been a more effective mechanism. But without really accurate data on cobras and accurate ways of identifying what measures a city takes for eliminating cobras, it's rather hard to regulate. And therein lies some of the issues of using regulation to manage something as complex as artificial intelligence. Instead, one writer, and I'm afraid I don't have her name here. Is it on the previous slide? Let's check. No. But one writer proposes, well, first of all, observes that given the pace of AI progress, laws will often be outdated by the time that they're passed. And that's kind of true, kind of not true. And it really depends on the law, right? If the law is specifying, for example, you must not leave CDs open for anyone to read, well then yeah, it's going to be outdated. But if the law is something like you should not leave data media open to be read, then that's a law that can be written that would pass at least some of the technological advancements that are taking place. Although, of course, after you move from data media to streaming data, your law no longer works. So, there is lag and there's lag. and it can be addressed by a more careful wording of the laws. Nonetheless, um, outdated regulations are a problem. And regulations that try to set specific metrics are a problem. So, what's suggested in this article, and I really do want to get the name of the person who wrote it here, so I'll just link to it. Uh, um, okay, the idea is based on work that Gillian Hadfield does. It's an interview article. The article itself is written by Jeremy Harris. And here it is. There you go. So, the idea then is to create regulatory markets for AI, a system whereby governments set safety metrics, here's an example, and then drive whole sectors of the economy to compete on those targets. But the trick, again, is Goodhearts Law. And it's going to be very difficult to write these regulations in such a way that they don't become targets for optimization and manipulation. And I forget where I saw this. I saw it just recently. Anytime you write a fairly detailed regulation, you're drawing a line, and you're pretty much guaranteeing that all the operators are going to squeeze up right along that line. Can't see what I'm streaming, so there we go. Because I'm holding my hand, I just want to make sure you can see it. Okay, so here's the line, right? And they'll be right up against the line to come as close to violating the regulation as possible, because the regulation is, according to their perception anyways, preventing them from making more money than they would if only the regulation were changed, or even better, if only the regulation were removed. And indeed, I saw an article in an Indian newspaper talking about the AI regulation being proposed in Europe, saying that it would cost 35 billion euros, which was a very specific figure. And maybe it does. Maybe it would. Maybe that's the amount of money that they would not be able to make by, optimizing for predatory AIs that use subliminal mechanisms and exploit vulnerabilities, etc. But of course, that article doesn't look at the wider social cost of not having such a regulation, and the reason for that is, obviously, those social costs can be offloaded to other people, to the rest of society. And so that's why there's the line. And that makes sense, and it's a good argument for regulation generally. What it's not a good argument for is clear and precise regulation that show exactly where you can go. And the argument that I read, and I'm in support of this argument, is that regulations should be written more vaguely, so that there isn't really a sense of a line you can approach to without quite crossing, that you're in the danger zone even if you're here and not quite at the line. And then as you get closer and closer to the line, the more and more you are in the danger zone. It's kind of like speeding limits. We have a speeding limit on the highway, 110 kilometers an hour. Everybody knows that the line for enforcement is not 110 kilometers an hour. Although I did see a police guy on TikTok saying, nope, it means you can never go more than 110 kilometers an hour, which is ridiculous, because that would make you a danger on the road, according to many people, including me. So you can go faster, but how much faster? Well, if you enter the province from the Quebec side, there's a great big sign that is actually like a buffet menu, right? And if you're caught doing 20 kilometers an hour over the limit, here's the fine, and you get a demerit. 30, here's a bigger fine and more demerits. 40, etc., until it's stunt driving. You receive like a $10,000 fine, roadside suspension of licenses, seizure of your vehicle, and all of that. So that's a vague law. It's vague in the sense that as you approach what really becomes socially unacceptable, the risks become more and more and more. So most people drive around 120-ish, maybe approaching 125. And then there's a few people who drive 130. They're willing to push it a bit, but it's 4-lane highway. So you can have variable speeds on the highway and it's all okay. That's actually a system that works and is quite the contrary of a system where a precise speed limit is defined, because now you're going to have everybody driving at precisely that speed limit no matter what the conditions are, whether or not it's safe to do, whether or not they're capable of driving at that limit. At least that's the argument. Again, I'm not sure you can create targets to optimize on without invoking Goodhearts Law. I like the idea of vagueness, but at the same time, I think regulation really only works well for those egregious situations like stunt driving, where everybody knows you're doing something wrong. The regulations won't prevent people who are unethical from doing unethical things, and they won't prevent people who are ethical, or they won't persuade people who are ethical to do ethical things. A way of saying it is you can't legislate morality. You can't create a law that people don't actually believe is morally right. Now, in some societies, in some cases, you can get away with it for a while, but maybe you shouldn't. And maybe what you're really doing when you pass a law that isn't supported by the bulk of the population is that you're legitimizing breaking the law, because nobody who's ethical would follow the law. I think that with respect to legislation, we as a society need to be aware of our limitations. I'm not saying that there should not be regulation of artificial intelligence and analytics, and certainly in the cases of the most risky applications, I think there's a good argument for doing so. But our discussion of ethics neither begins nor ends with those regulations, and those regulations indeed are dependent upon our discussion of the ethics. If it turns out that there's nothing unethical in using subliminal tactics, then they wouldn't be considered risky or against the law. So we need a better understanding, or we need to be able to understand what the ethical foundation is for our beliefs about what's risky and what's not risky. And it's tricky. It's tricky because people don't understand AI, especially the legislatures. And it's tricky because even those who do understand the AI don't necessarily agree that there are the sorts of risks that people say there are. So any legislation, any legislative approach that we're going to take to artificial intelligence today is going to be tentative. It's going to be a best effort sort of thing. We should think of it as draft. We should think of it as beta. We're not sure now what the impact of the legislation will be. We're hoping it's good. And we're using our best judgment, I would hope, to make good regulations, and the incentive for regulation really is to avoid the worst harms, and which is a consequentialist position. And it's kind of a, I don't want to say crass material position, because that's not quite it. But it's one that doesn't get at the nuances of what we think is right and wrong in artificial intelligence. So regulations, legislation will only take us so far, and is dependent on what our ethics already are. So we're going to take a step down our staircase and look more at what we think good practice is generally, without thinking about how we should legislate good practice into law. But that's for another video. So I'm going to stop here. I'm Stephen Downs, and moving forward in Module 8. Bye for now.